Thanks for joining us on the Voice of Job Seekers podcast. This is Mark, your host. And hopefully, if you have any questions about the podcast or the blog, feel free to go to thevoiceofjobseekers.com. I hope you had a great holiday, and hopefully that your start of January is a productive one. I welcome back to the show Tom Spiggle of Spiggle Law. Tom is a former prosecutor and former assistant U.S. attorney. His website is a very informative blog found at spigglelaw.com. He's regularly quoted in media such outlets as Washington Post, CBS News, and many other law journals. How are you, Tom?
Just fine. Thanks for having me on.
Good. As we were discussing, 'tis the season for layoffs and firings and different types of separations, whatever people will call it. I think the Bureau of Labor Statistics clumps layoffs and departures as separations. But you have a 6-part series to offer when people sign up, and you have something else to offer, and I'll leave that to you when you want to mention it. But I really want to grab a hold, or at least describe for my audience, how would you describe the differences between a separation agreement and a separation package?
Well, a lot of it is just semantics. There's no legal difference. A separation agreement or a severance agreement, sometimes they're used interchangeably, is generally just the agreement itself. Mm-hmm. So the actual piece of paper and the legal obligations that each party is entering into. Essentially, there are other bells and whistles, but essentially it's you are agreeing not to sue in exchange for money is usually what that is. Mm-hmm. A separation package, what usually people are talking about is, you were talking about layoffs, if there's a significant number of layoffs in the company, sometimes they'll call it a reduction in force. Separation package can be just a package of benefits that can include not only the separation agreement, the actual legal document, the paper that both sides sign, but it could be, job placement kind of programs. Sometimes if you have to moving expenses, these tend to be for larger companies, have kind of a set package that they offer people that are subject to layoff. Mm-hmm.
Mm-hmm. Now, there are companies, I don't know. And a couple of thoughts came into my mind. First of all, not every company is going to offer a separation package. It's traditional. It's kind of as a courtesy. I don't even know if courtesy is even the right word. But there are times when there are companies that won't offer anything.
Sure. And they're not legally required to. You're right. It depends on the company. It depends on the situation. Again, if it's a large company and it's a big reduction in force, likely they're going to be offering you some kind of separation package, which again involves, you signing an agreement in exchange for some money and perhaps getting some job training. But in other companies, if you're just let go, there's no obligation for the company to offer you a severance or a separation agreement. Again, it's the same thing legally, whether you call it a severance or a separation agreement. Mm-hmm. A lot of times the company, will offer one if the company perceives it to be in its best interest. Either it does that by practice for a long-time employee, or the company is concerned about liability. Because one thing you have to remember in signing that agreement is that, the company's getting something for it. And that is you're waiving any right that you might have to sue the company or to bring an EEOC charge for anything that may have gone wrong that was, unpaid wages, those sorts of things that could be the company's fault. That's often companies will offer them for that reason, to protect the company.
I see. So really, when somebody starts to hear news of a separation, is there any particular way that you would think that people would like to kind of have a mindset? Of course, there's never any way to prepare for of any kind of layoffs or large layoffs. Usually, no matter how long ahead you get noticed, that the shock is still the same when it happens to you. But when you hear those kind of things, is there anything that you should listen for to maybe better buffer the blow?
Well, I mean, of course, folks should use services like yours to get ready to look for that next.
Sure.
I think it's never a bad idea if you have a financial advisor to talk to him or her to kind of get your financial ducks in a row, because if you're prepared, sometimes that way it will soften the blow. I mean, of course, always keep, as you do, most people do, keep your ear to the ground in the company. If you can get a sense of what kind of packages are being offered, that's helpful to know. And if the company is open to negotiation about the size of the package, how much you're offered. I mean, all those things can be useful pieces of intelligence to have. Another thing to consider is if you think that you are about to be fired or laid off, if there's something sometimes things will go wrong in a company. Let's take, the subject, that's timely now, perhaps it's some sexual harassment, whatever it may be, that you haven't reported because you want to keep your job. Or you've seen somebody else go through it and you were afraid to report it because you want to keep your job. Now's the time to report it. Not only because it's the right thing to do, but because it puts you in the strongest legal position possible to try to get a larger severance agreement. Because if you wait until after you've been fired, or you've been offered the severance package, it doesn't have nearly the same effect. The reason that is because once you report, say it's before the severance has come down or before you've been fired or laid off, then you have, depending on the size of your company and what it is that you raised, you may have anti-retaliation protection under federal law, which is different from a substantive claim you might have, say, for discrimination or for wrongful termination or for unpaid wages. It's a separate kind of claim. And so if you are looking for, any kind of leverage that you can use to severance package, you want to have that on the table before they call you down to HR.
Right. I think one of the things that people might have a question about, they heard you say negotiation. And just to be clear, and I guess we can kind of get into the components of the separation package. You mentioned 5 in your article. If you don't mind kind of giving a brief synopsis of each, and then I'll probably go from there to ask the question I really want to ask.
Yeah, sure. And remind me if I leave any off the table. So kind of some of the here are the kind of the key ones. The first one that you want to, well, let me start out and say, often there are things in the severance package that may not be of any particular use at all to you. For instance, if there are some severance packages have like whereas clauses where they'll say whereas this and whereas that. Those have almost no legal significance whatsoever. I frankly would just ignore them. The second piece you want to look at is, and probably the biggest piece, is, of course, the money. What are they offering? And sort of the rule of thumb, although this isn't a legal requirement by any means, sort of the rule of thumb is a week for every year of service. If you're higher than that, if they're offering you more than that, then it's sign of one of two things. It's either a good severance package, or it is a sign that the company thinks they've got some exposure. That is, they think they've done something wrong with you, and they're trying to sweeten the pot to get you to sign the deal.
Right.
And then if it's less than that, it might suggest the company's being a little stingy and offer a room for negotiation. So that, in comparison, which the biggest part is, which is the release of claims. And the release of claims is usually pretty easy to spot. It's usually a big paragraph with a bunch of legal gobbledygook for non-lawyer types. It'll mention statutes, Civil Rights Act of Title VII of the Civil Rights Act of 1964, the Fair Labor Standards Act. I mean, it'll have usually everything but the kitchen sink in it. And the important thing to know is that usually what you are doing is you are releasing any right to sue for anything leading up to that agreement. I mean, if you find something later, you can still potentially sue. Certainly, if there's a breach of the actual severance agreement, if you end up signing it, that can still be litigated. But anything prior to that, if you were subject to sexual harassment, if you were subject to discrimination, if you weren't paid all of your wages, you are giving up your right to bring any kind of lawsuit. Now, it's important to remember that it's actually illegal to prevent you from going to the EEOC. So you can still go to the EEOC and file a charge, but it is legal for the company to require you to relinquish any money damages you might win. Mm-hmm. So while you go to the EEOC, you're not going to get any money for anything that might happen as a result of litigation there. So that's a big one. It also does not bar participation in a criminal investigation. So, we've seen a lot of this in the Weinstein and the kind of fallout over the sexual harassment. A lot of women signing non-disclosure agreements and those sorts of things, and some concern by some people about them being prevented from going to the authorities. Can you still? We good, Mark?
Yeah, I'm here.
I'm here. I lost you there for a second. But you can still, talk to the authorities, and so you're just not waiving your right to do that. So, so that's a big. Then the other biggest piece is the non-disparagement clause, and that usually is that the company, you agree not to say anything within reason bad about the company, and usually in exchange, although this is something to watch for because sometimes companies won't put it in the first instance, you are agreeing not to say anything bad about the company or to reveal the amount of your of whatever it is that you were paid. Mm-hmm. You want to make sure as an employee that the company is then agreeing also not to say bad things about you, and if possible for you to negotiate some kind of reference. At the very least, what's called a neutral reference. That is, if a company, if you're applying for jobs later and you give this older company as a reference, when they call, they'll basically give, that you worked there from, however long you worked there, your title and your salary. And those are very common to have those kinds of, those kind of, neutral references as part of those.
Yes, agreements. It is. Yes.
Another thing to look at is if there is a dispute, and this is usually in the agreement itself, what the choice of law is. You want to look and see, because you can agree to which state law is going to apply. So if you, for instance, and it usually will be the state that you work in, but you got to watch it because sometimes it will be at corporate headquarters. So you could be, I'm located in Virginia. You could be at a company located in Virginia, but that says the choice of law is California. It's not necessarily something to negotiate over. It's kind of hard to say whether that benefits you as an employee or not later on down the road, but it's something to be aware of. Mm-hmm. I think the final thing now is non-compete. A lot of times companies, even if you have not agreed to a non-compete, it'll either a non-compete that you've signed, or it will include a new non-compete. And that is something, of course, you want to be really careful with, because it doesn't do you much good if you're negotiating a severance package, but then you can't turn around and, work for the next year within your, geographic area. So those are sort of the, some of the bigger pieces of it. I think I only hit 4. Is there a 5th one that I left out?
Well, let's see. I think you kind of covered references, payment benefits, unemployment, you touched on, and let's see, obligation. So you touched on all of them, I think, all 5 of them.
I think the benefits is another good point. Is you want to, you want to make sure that the benefits are included as part of the package. If there's going to be a package offered, that your health care is taken care of. Sometimes companies will, you are required to be offered COBRA, the right to continue your insurance. Mm-hmm. But it usually is going to be a lot more expensive if the company has been picking up part of the tab. So sometimes you can negotiate the company to continue to pay part of that. And then, yes, unemployment insurance. Sometimes you can get a company to agree not to oppose your application for unemployment insurance benefits.
Right. Now, unemployment, as far as unemployment is concerned, there are times when a company doesn't pay or doesn't allow that bridge between being paid as an employee and receiving unemployment.
And what do you? I'm still following.
Okay. Well, if I'm laid off one day, then I go to apply unemployment, and then you're told when you apply for unemployment that the company doesn't pay into unemployment insurance, or they don't have any available for the company, and sometimes, that's happened.
Yeah. No, it's a good point, and they're required to by law.
Right.
It'd be something that would be, probably taken up by the state agency that handles that. I don't think as a private citizen you would have any recourse for that. That is, be able to sue them. I think the state could bring an action against them, but there's probably in the short term, unfortunately, not a whole lot you can do about that if they haven't been paying into the system.
Right. Yeah. Especially if the company's dissolved.
Right.
Then there's no company to sue.
Exactly. You might just be out of luck.
You mentioned something about being able to negotiate some of the terms of negotiation. Of course, there are some that are and some that aren't, and they vary per company. But it is possible that particularly with the larger companies, that you can negotiate the terms of not just a payment, but how your separation will be worded. Is that correct?
Yeah, it depends. And again, it depends on the size of the company and the nature of the layoff. And some of the really big companies, if it's a large reduction in force, you may find them very reluctant. Sometimes it can be close to impossible to get them to change the wording of the agreement because they use it for so many employees. I don't know if they have to change it for one person, they have to change it for everybody. But that's not to say it's not worth asking. I mean, the worst they can do is say no. But in a lot of companies, you can change a lot about the severance agreement. Not only the money that's offered, but again, I'll give you an easy one. Like a lot of times we'll see in the initial offer from the company that they'll ask for a non-disparagement company in which the employee has to agree that they're not going to say anything bad about the company, but there's no corresponding obligation by the company not to disparage the employee, or there's no agreement about what kind of reference there's going to be, and that's something that can be. I mean, remember, even if there has been nothing that's gone wrong at the company, even if there's been no discrimination, even if you don't have any, you don't have any reason to believe that anything has been done wrong, you're still giving the company something by signing the agreement. And one is you are agreeing not to sue. And again, it may be that you don't have anything, but the company doesn't necessarily know that, and they get off scot-free. And remember, if you don't sign it, you can, within reason, walk away from that company and say whatever you want. So if you're if you're not subject to a non-compete already, you're not subject to that. You can walk away. You're footloose and fancy free. So by signing it, you are giving the company probably a non-disparagement. You are giving the company relief in knowing that they're not going to get sued. You may be giving the company some restrictions on which kind of jobs you're able to apply to. So, it is still a value to the company, even if looking at it, you're like, well, I don't really have a reason to sue. It is still a value to the company to get that signed document. So don't be afraid to ask for some of these things, for more benefits, for more money in severance. And sometimes, kind of a 25-cent legal word, we call it arguing the equities, which basically means just arguing fairness. Mm-hmm. You've been with a company 10 years and they're offering you 2 weeks of severance. Well, that's pretty chintzy. You can say to them, look, I've given you 10 years of service. My understanding of the rule of thumb, it's a week for every year of service. I'd like to at least get 10 weeks of severance. Again, a lot of times you'll find that this is a negotiation just like buying a car or buying or selling a house. Sometimes the company's going to start low, and there's some room there for them to give.
Yeah, I think one of the things that people can also have to be prepared to do is kind of just stay engaged to the news, companies, newsletters, and different signs that you may hear that you may need to start to prepare weeks ahead of time before you can really start to have a true, meaningful, and valuable discussion with the employer if that time should come. Um, I know there are many times when people will get pink slips and then they don't actually have to worry about being laid off because they never enact on them. And then again, there's sometimes you may get it a pink slip, and there's so many days that you have um, to at least prepare for it. But there are times when people really don't believe that it's going to happen because it didn't happen before when they got the pink slip. So
Yeah.
it takes a little time and thought to be prepared for layoffs and severance. But then again, there are people who are blindsided.
Yeah.
As we learned in the late 2000s of all the big companies, like you remember Bears and Stearns.
Oh, yeah.
I
Right.
mean, places like that can fall apart in literally no time. So really, there's no set, but it does kind of pay to kind of be engaged when you start to hear, even if it's just a rumor, start to look at what you have and what's available to you, and kind of listen to what other people are saying. So there's some value in that. Anything else that we didn't cover? I think you hit it all pretty much on a basic level.
Yeah, I think one more piece while I'm thinking about it, when we talk about being blindsided, a lot of times we'll get people who will call us and they'll say, I think I'm about to get laid off, or I think I'm about to get fired. Should I come in and talk to you now, or should I wait until I get my package? We'll see what the offer is. And that there's no one answer to it. I think if you believe, for example, you've been holding on to something, maybe some wrongdoing within the company, you perhaps whistleblowing information, and you just haven't acted on it, or you believe you were the subject of discrimination, or you're not sure, then it might be useful to go talk to a lawyer first. But I think most lawyers, one way or another, are going to want to see what that severance package is in order to give you the best advice. Which brings another piece is like how long do you have? I think a lot of people, like with the calls that we get, people are like, okay, what should I do in the meeting? If I get called in by HR and laid off or fired. And our advice usually is, again, it can vary circumstance to circumstance, but generally is say as little as possible. It's not as if this is a criminal proceeding. They're going to hold things against you, but it's not as if you can talk them out of them. You need to go negotiate right there on the spot. Listen to what they have to say. Take notes if you need to. Keep your wits about you. And then if you need to, call a lawyer after that. Because this is another question. How long do you have to consider the agreement? I think a lot of people are concerned, that they're going to have to sign it that day. And the truth is that is very rare. And in fact, if you're over 40, the Older Workers Benefits Protection Act requires that you be given 21 days to consider the agreement, and then 7 days after that to change your mind, even after you've signed it. So if you're over 40, you've got that 21 days to consider. But the truth is, most companies will give you that time anyway. I won't say I never see it happen, but it's rare that we have somebody that says, I was offered this severance agreement and they told me I had to take it or leave it that day. So just know that 99% of the time, if you get called in that meeting, take a deep breath, listen, keep your wits about you. Feel like you need to read that agreement right there, take it out of the office, take a moment to collect your thoughts, and then look through it. And if you need to, you can certainly call a lawyer, or decide if you want to try to negotiate it. Take it home, talk to your husband or wife if you have one, and take a little bit of time to sleep on it and think about it. Don't be pressured into acting on it right then.
Right. Well, Tom, this is such valuable information. I think most people don't know how to respond to it. I thank you very much for your time, for
Sure.
spending with us once again. You know I'm going to ask you to come back on here here in the few months ensuing,
You still
because
there? Here we go.
yeah, we just got to pick up on our discussion that we had before, to see what comes down the line as far as how the different Trump administration laws will enact and how it will affect job seekers here in the near future. But
No,
nevertheless, I want to thank the rest of you for being a part of the Voice of Job Seekers podcast. Again, if you want to go to thevoiceofjobseekers.com, you can check out all the articles and podcasts that are available. There, you can press the send voicemail message. You want to leave me a message or a question about this particular episode. If it gets really deep out, maybe Tom can come back on to answer some of those questions in the ensuing months. Nevertheless, thank you again. If you
hey,
haven't, go ahead.
can I
Go ahead,
just
Tom.
mention, I've got an online program now.
Yes, go ahead.
Yeah, that's called the DIY Legal Leverage Program, which is designed for folks, who are perhaps they have a severance agreement that they're looking at, or they're facing some kind of job difficulty, and it's a 7-step video and e-course that we are offering. We are eventually going to offer it for sale, but I'd like to offer it for free to any of your listeners. And if they want to get access to it, I can send you a link too that you can put in your show notes.
Awesome.
But they can also email my assistant, Dana Brunson, and she's at DBRUNSON at SpiggleLaw.com. That's that's DBRUNSON at SpiggleLaw.com. Just email her and let her know you want to get access to it, and we'll be happy to give it to your listeners for free. All that we ask is for folks to let us know what they think about it and give us kind of their thoughts on it. It'd be very helpful.
Okay, this is really generous of you, Tom, and I want to just let my audience know we're publishing the show on January 19th, so you're listening. People tend to listen down the line, but if you're listening as soon as you are around that time, please start to engage immediately. We're talking about probably a few $100 value in that particular package that he's offering free to you guys. So take advantage of it, even if it's just for future reference and you want to keep it, and feel free to give Tom feedback. That's what he's looking for. It's going to be a test in beta format, as well as for the rest of you. If you are looking to conduct a modern job search, and some of you are still writing objective statements on your resumes, you'll need my free e-guide, 118 job search tips for the modern job seekers in 2018. And this is your year, and this is a great way to get started. And the guide will lead you to a lot of different resources and get you to start thinking about your job search in a different way that you never had before, especially if you haven't done one the past 2 or 3 years. So great resource right there. Again, thank you. Look forward to talking to you guys in the next episode.